On the state's guide to the test, they list 26 Supreme Court cases you need to know. Now, as a comparison, the AP US government test has 14 Supreme Court cases that you need to know. So the state's FCLE has more court cases than AP government. I personally think it's kind of crazy, but I can't do anything about it. The best I can do is help you prepare for it. So we're going to go over 26 Supreme Court cases today. Now, I mentioned using process of elimination. Not that I would know, but I might have heard from somebody that one of the questions could be a case that's not listed in the 26 Supreme Court cases. But what they'll do is they'll list something about a case, they'll ask something about a case that's not in the 26, and there'll be 4 choices. 3 of them will be cases you should know. 1 will be this other case. So you can use process of elimination if you know the other 3 cases and say, well, it's not any of these 3, so it must be this 1 remaining case. They shouldn't do that on the test, but you know, state tests sometimes do weird things. But use process of elimination. Okay, so the very first case you need to know is Marbury v. Madison. You don't need to know the years, but just to give you some sort of concept of how we're moving through time and everything. This is early on in the United States history, and Marbury v. Madison is a case that establishes something called judicial review. You do not need to know a lot about the background of this case. It has to do with the appointments of judges and dispute between presidents, Adams and Jefferson. You don't really need to know any of that. What you need to know is that Marbury v. Madison established the concept of judicial review, and that is the ability of courts to say that a law is or is not constitutional. The courts can review laws and decide if they fit the Constitution. If the courts decide that a law is unconstitutional, they can invalidate the law. They cancel the law. So that's what you need to know about Marbury v. Madison, is judicial review. The next case is McCulloch v. Maryland. In this case, McCulloch v. Maryland, Congress created a national bank. So this is again 1819, fairly early in U.S. history. The United States Congress decided to create a national bank as a means of helping to regulate the commerce, the economy. So Congress created this national bank. One of the branches of the national bank was in Maryland. Maryland decided they were going to tax the bank. They passed a law specifically taxing just the national bank. So the United States government decided they were not going to pay this tax, and it ends up going to court. The Supreme Court had to decide 2 questions. First, can Congress create a national bank? Maryland was claiming that the government had no right to create the bank in the first place. Okay, so can Congress create the national bank? Second, if Congress can create a national bank, can the state of Maryland tax that bank or tax a part of the federal government? So those are the 2 things the Supreme Court had to decide. The Supreme Court decided that there's the necessary and proper clause of the Constitution, and it does give Congress the power to establish a bank. The necessary and proper clause says that Congress can do all the things necessary and proper to fulfill its duties in the Constitution. That means that even though the Constitution doesn't say that Congress can create a bank, it does say that Congress should regulate the economy, and it seems reasonable that Congress could create a bank for the purpose of regulating the economy. So that's necessary and proper clause, that Congress can do anything necessary and proper to carry out a function specified in the Constitution. So Supreme Court said Congress can create a national bank. Then the Supreme Court said because of the supremacy clause, the state could not tax the national bank. The supremacy clause says 2 things. One is that the national government wins in disputes with the state government, and the Constitution wins in disputes with Congress or the states, any law. So if there's a dispute between, or say 2 conflicting laws, one national law, one state law, the national law wins. The nation is more important, more powerful than the states. And if there is a dispute or a conflict between a law and the Constitution wins. So that's the supremacy clause. So in this case, they said the state could not tax the national government because in order to tax somebody, you must have authority over them. And the state does not have authority over the national government, therefore it cannot tax the national government. So that's McCulloch v. Maryland. Two things: necessary and proper clause, Congress can create a national bank, and the supremacy clause, states cannot have power over the national government. Now we're going to get into three cases that relate specifically to Black Americans: Dred Scott v. Sanford, Plessy v. Ferguson, and Brown v. Board of Education. The Dred Scott case happened in 1857. Important thing about this is that it happens before the Civil War. So in this case, Dred Scott was enslaved and he was living in a slave state. His owner took him to a free state and then eventually brought him back to a slave state. Dred Scott claimed that the moment he entered a free state, he became free, because you can't be a slave in a state where slavery is illegal. He said, I became free. When I went back to a slave state, I was still free, because once you're freed, you're freed. So his owner said, no, you're in a slave state, you still belong to me. Dred Scott went to court arguing that he would be free. The Supreme Court decided that they didn't even need to decide whether or not entering a free state made him free, because as a black person he had no rights, so he couldn't sue anyway. So the court case just gets thrown out completely. This is later nullified by the 14th Amendment, which is one of the Reconstruction Amendments after the Civil War, because the 14th Amendment says that everyone born in the United States is a citizen regardless of their race. So the whole idea that blacks have no rights is nullified after that. As a side note, just historically, you don't need to know this for the test, the Chief Justice of the Supreme Court at the time was a Southerner and very staunchly pro-slavery, and he thought by making this decision it would settle the issue of slavery by saying nationally blacks have no rights. It doesn't matter what your state does, you can say whatever you want. The official Supreme Court decision is blacks have no rights. But all that did is make Northerners even more upset and kind of lead to the Civil War. But again, the Civil War then nullifies the whole thing with the Reconstruction Amendments, specifically the 14th Amendment, which made all people born in the United States citizens. So that's Dred Scott v. Sanford before the Civil War. Now, when we get to after the Civil War, now, according to the 14th Amendment, Black Americans have equal rights. But the state of Louisiana passed a separate train car act, which said that blacks and whites had to ride in separate train cars. Homer Plessy was part black, part white, fairly light-skinned. He bought a ticket, sat in the white section of the train. The train conductor asked him, are you white or black? He said, I'm black. He was told to move to the black car. He said no. He got arrested. Incidentally, this was all staged. He wanted to get arrested because there's something called standing. You can't sue unless you've been harmed. So he needed to be arrested before he could sue. Him and a group of friends called the Citizens Committee purposely wanted him to be arrested so they could challenge this segregation law. So he got arrested. He then said that his 14th Amendment rights were violated. The 14th Amendment has something called the Equal Protection Clause. The Equal Protection Clause says that all citizens are entitled to equal protection under the law. He said that he was not being equally protected because he was being discriminated against through segregation. So this goes to the Supreme Court. Supreme Court ruled that segregation was legal under a doctrine they created called the separate but equal doctrine. The Supreme Court said that blacks were not being discriminated against in any particular way because whites were discriminated against too because they had to sit in the white car. So, you know, it's all equal. It's not unequal at all. So Supreme Court came up with separate but equal, and Plessy lost this case. Then we get to 1954, Brown v. Board of Education. The NAACP had been working through the courts with a whole bunch of different cases. In this particular case, the NAACP claimed that segregation causes social and psychological harm regardless of whether or not the facilities are equal. This was specifically about schools. They had cases where they argued that some black schools were of lower quality, less funded, things like that than white schools. But in this case, they were saying even if the black schools are equally funded, equally high quality and everything, simply by segregating people, you are causing psychological harm because the implication is that something's wrong with them. Otherwise, why do you need to segregate them? Why do you need to separate them unless something's wrong? So this goes to the Supreme Court, and the Supreme Court decided that segregation was a violation of the 14th Amendment. And they said that separate is inherently unequal. So therefore, Plessy was overturned. Plessy is no longer the law. It was overturned by Brown v. Board of Education, and now segregation is illegal. So those are three court cases regarding black Americans that you need to know. Next case is Schenck v. United States. This is 1919. Now, anyone know what happened between 1914 and 1918?
First World War?
Yeah, World War I. So this is right after World War I. It actually started during World War I, but it takes time to work its way through the court system. So it wasn't decided until 1919. But Schenck was a pacifist, and he wrote a pamphlet advocating that people refuse to join the draft because they should not support the war. He was arrested and convicted for violating the Espionage Act, basically saying that he was helping the enemy by weakening the United States military. He then claimed that this was a violation of his First Amendment, freedom of press and freedom of speech. He can express his views. It went to the Supreme Court, and the Supreme Court ruled that the First Amendment doesn't protect him in this case because he was creating a clear and present danger. So basically, you have the right to free expression, but you can't express something that creates a clear and present danger to the people around you or to the United States. And by weakening the United States military, this created a clear and present danger. Now, if something like this happened today, the Supreme Court would decide very differently. But in 1919, they decided against Schenck. Then we get to Korematsu v. United States. This is one of the cases I think is fairly easy because Korematsu sounds like a Japanese name. So you just have to remember the Japanese name, Japanese Americans, internment. So during World War II, 1944, Franklin D. Roosevelt ordered that all the Japanese Americans, regardless of whether they were citizens, whether they were born in the United States, any of that stuff, be sent to internment camps if they lived over on the West Coast. Korematsu didn't report to an internment camp. He changed his name, lied, tried to hide out. He eventually got caught and sent away to an internment camp. He then sued and said that this violated his due process clause rights under the Fifth Amendment. The due process clause says the government cannot take away your rights without giving you due process, which is a court hearing. You have to be accused of something. But in this case, Japanese Americans were not actually accused of anything, and there was no court hearing or anything like that. They were just ordered basically to go to jail. So he argued that this violated his Fifth Amendment rights. The Supreme Court said, it's time of war, we all have to make sacrifices. Some people get drafted and sent off to war, you got sent to jail, it's all good. So the Supreme Court ruled against Korematsu. Again, because of wartime, just like with the Schenck case, the Supreme Court said the government can do a little bit more during war. Then we get to the case of Mapp v. Ohio, 1961. Dolly Mapp's home was searched without a warrant. Police were looking for somebody who was suspected of a bunch of crimes. They heard that the guy was hiding out in Dolly Mapp's house. They broke into the house, searched. They didn't find the guy, but they did find evidence of gambling and pornography, which were both illegal in Ohio at the time. And she was convicted, and she appealed on the Fourth Amendment. The Fourth Amendment is the one that says government cannot search your house without a warrant. SCOTUS, in this case, did something called incorporation of the Fourth Amendment. Because if you know the First Amendment says Congress shall make no law. When the Bill of Rights was written, originally it only applied to the national government. It only said Congress couldn't do these things. It didn't apply to states. It wasn't until the 14th Amendment, after the Civil War, that the Bill of Rights was applied to the states because the Equal Protection Clause of the 14th Amendment said that even states couldn't violate your rights. Because obviously it's the end of the Civil War, we have the Reconstruction Amendments. We want to make sure that the southern states aren't violating people's rights. So it incorporated or said that the Bill of Rights applied to states. But it didn't automatically take all of the Bill of Rights and apply it to the states. Courts had to, over time, decide which parts did and didn't apply. And in this case, the Supreme Court decided that the Fourth Amendment did apply to the states, so state and local police have to follow the Fourth Amendment. So again, incorporation doctrine is the process of the courts extending parts of the Bill of Rights to the states. So Mapp v. Ohio, the Fourth Amendment did protect Mapp, and her evidence was thrown out. Baker v. Carr, a 1962 case. In this case, Tennessee had a law that required their congressional district maps be redrawn every 10 years with the census. So as populations changed, the maps of their districts were supposed to change, but Tennessee hadn't actually done the drawing in more than 60 years. Now, this is 1962. You go back 60 years, a little bit more than that, it was actually late 1800s. So basically, how was America changing between the late 1800s and the mid 1900s? A lot of industrialization, moving to cities, all sorts of things like that were happening. So places like Memphis were becoming big cities, while a lot of rural farming areas were losing population because with machines and things like that, you didn't need as many farmers. So when you weren't redrawing the maps, big cities like Memphis weren't getting any more representation. Rural districts weren't losing any representation. So Baker sued and said that he was effectively being denied equal representation based on the population because the maps were 60-something years old. Baker lived in a growing urban area, Memphis. Supreme Court ruled there's a principle, one person, one vote. Everybody's vote should be roughly equal. That means that if you have 10,000 people over here that have a representative, then over here, a representative should also represent roughly 10,000 people. You need to keep the districts up to date with the maps. So this principle, as part of the Equal Protection Clause, that everybody has equal protection under the law, 14th Amendment, required the state of Tennessee to redraw their maps. So now, every 10 years, with the census, they have to redraw their maps. So Baker v. Carr, know the one person, one vote principle as part of the Equal Protection Clause of the 14th Amendment. And one person, one vote is going to come up again later in another Supreme Court case. Engel v. Vitale, another 1960s, 1962 case. New York passed a law that allowed school districts to choose, if they wanted to have school start with a school prayer. It was a very generic school prayer, very short. It was written through a team of people representing Christian denominations and Jewish groups and stuff like that. So it was very generic, but it was a monotheistic prayer, single God. Engel sued and claimed that this was a violation of the First Amendment, freedom of religion. It went to the Supreme Court, and the Supreme Court ruled that school prayer did in fact violate the Establishment Clause of the First Amendment. Because the First Amendment says that you have the right to practice whatever religion you want, and that Congress shall make no law respecting the establishment or creating a national religion. Of course, the schools in the state were claiming that it wasn't a single national religion because you could be Jewish, you could be Christian, you could be Muslim, anything. But the Supreme Court ruled that it's still monotheism, so it's still establishing a religion. So, school prayer banned by the First Amendment. Next case, 1963. A lot happening in the 1960s. If you know much about American history, there was a lot going on in the 1960s. Okay, Gideon v. Wainwright. Gideon was accused of stealing some things from a bar. He was arrested. He asked for a state-appointed attorney. Gideon only had an 8th grade education. He was very poor. He had no money. And he asked for the government to give him an attorney. But this was in Florida, and Florida at the time only gave people a free government-paid attorney if it was a capital case where they could face the death penalty. So he was not facing the death penalty, and the state denied him his attorney. He went to court representing himself and lost. So then, when he was in jail, he appealed to the Supreme Court. And the Supreme Court, he claimed that the Sixth Amendment gave him the right to an attorney. The Sixth Amendment says that all people have the right to an attorney. But of course, the government was claiming that you have the right to have an attorney, you just don't necessarily have the right to a free attorney. So that was the question that the Supreme Court had to decide. And the Supreme Court ruled that indigent or poor defendants must be given an attorney for free. Generally speaking, you don't have the right to things for free. Like, you have the freedom of press, but you can't say the government has to provide you a printing press. But in this case, in order for us to say that we have a truly fair, impartial criminal court system, we can't have a system where poor people have to defend themselves and rich people can pay for an attorney. That just doesn't make sense. That's not going to be a fair system. So in this case, the government decided that if you are too poor to afford an attorney, the government will provide one for you. That leads into the next case. A few years later, Miranda v. Arizona. Miranda was arrested and he was questioned by the police. He did not ask for an attorney and he ended up confessing to the crime, and he signed a statement confessing to the crime. Of course, he was convicted. He appealed on the grounds that he didn't know his Fifth Amendment rights, that he does not have to testify against himself. He does not have to admit to it. And he didn't know he had the Sixth Amendment right to an attorney. So he appeals, claiming that he should have been told his rights. And the Supreme Court ruled that the accused must be told their rights. You must be told when you're arrested that you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney will be provided for you. And those things together are called your, anyone? Miranda rights. They're called your Miranda rights because of this case. So Miranda built on the Gideon case. The Gideon case said you have the right to an attorney. Miranda said you have the right to know that you have the right to an attorney and the right to not self-incriminate. So now you have your Miranda rights. Later on in the 1960s, we have a court case called Tinker v. Des Moines School District. These are high school students who wore black armbands. Black armbands were traditionally a sign of mourning, something wrong. They wore the black armbands with a peace symbol on them to protest the Vietnam War. They were suspended or expelled. If you read about this case online, sometimes it'll say they were suspended, sometimes it'll say they were expelled. Technically, they were told they were suspended and could come back when they weren't wearing the black armbands. So it was an indefinite suspension. You know, you're suspended for as long as you refuse to take off your black armbands. So they ended up suing, claiming that the school violated their First Amendment free speech, freedom of expression rights. So the Supreme Court had to decide, do students in public school have the right to protest the Vietnam War? Supreme Court ruled that the school did violate the First Amendment rights, though the Supreme Court said schools can make rules for safety. In this case, the school claimed that they were worried about violence because protesting the Vietnam War was very controversial, and they were afraid it could lead to fights or something like that. But there was no evidence that fights were going to happen. There were no actual threats or anything like that. The school just had some sort of vague worry about it. And so the Supreme Court said if there was actually evidence of violence that was imminent or something like that, the school could do something. But just having some vague idea that this could lead to violence wasn't enough, and the students did have the right to protest. Also, students cannot disrupt education. So you can protest, you can wear a black armband, but you can't like start chanting in the middle of class or something like that. You can't disrupt education. But they weren't doing that. So students won in the Tinker v. Des Moines case. Another First Amendment case, New York Times v. United States, 1971, still during the Vietnam War. The New York Times was leaked a big treasure trove of documents, collectively called the Pentagon Papers. Early in the Vietnam War, the Pentagon had commissioned a big study, and the study had concluded they were going to lose the Vietnam War. Now, you can imagine what the Pentagon does with this big study saying they're going to lose the war. They buried it, did nothing with it. Someone leaked the documents to the New York Times, and the New York Times started publishing the documents over a period of time because there was thousands of pages of them. The government sought to get a court order to stop any further publication, and the New York Times sued, claiming their First Amendment freedom of press rights were being violated. So this goes to the Supreme Court. The government tried to claim clear and present danger, just like in the Schenck case, you can't endanger people. They said that by releasing these secret documents from the Pentagon, it was a danger to the troops in Vietnam. But SCOTUS ruled that there was no clear and present danger because the documents by this point were years old and they didn't have any specific things like, we have these troops in this location or anything like that. There was nothing useful to the enemy other than the fact that the US government knew years ahead of time that they weren't going to win the Vietnam War. So in this case, there was no actual clear and present danger, and the New York Times won. They could publish the Pentagon Papers. Another freedom of religion case, Wisconsin v. Yoder, 1972. Yoder is an Amish name, a common name among Amish people. So if that helps you remember this, it's a case about Amish people. Can the Amish be required to send their kids to public high school? Wisconsin in 1972 had a law that required all kids to go to public school until they were 16 years old. The Amish said high schools taught things that went against their religion, and they didn't want their kids going to high school. They were willing to send kids to school through 8th grade, just not to high school. So this goes to the Supreme Court. Supreme Court ruled that, yes, it's nice to give them a few more years, because you figure 8th grade's 13, 14 years old. So you're getting 2 or 3 more years if you go to 16. That it is nice. There is a real benefit to getting 2 or 3 more years of school. But that extra benefit of 2 or 3 more years is not enough to outweigh their First Amendment free exercise clause rights. The free exercise clause says you can freely practice your religion. So basically, you have the right to freedom of religion. The government can restrict that in some ways if they have a very good reason to do it. But in this case, it wasn't so significant. The Supreme Court also had lots of other little things in there, like the Amish people didn't just pull their kids out of school at 8th grade and then let them sit home and play, Switch or something like that. The Amish people still educated them in farming and taking care of animals and construction because they build their own houses and all sorts of stuff like that. So the Supreme Court said it's not like they're getting no education. They're still being educated how to live productive lives within the Amish community. So for a variety of reasons, the Supreme Court ruled that the Amish did not have to send their kids to school past 8th grade. So the First Amendment did protect the Amish in this case. Okay, Roe v. Wade. Roe v. Wade is a case about abortion or reproductive rights. Can states restrict access or limit access to abortion, outlaw abortion, also known as reproductive rights? It's very important that you know the phrase reproductive rights. Not that I can tell you it's going to be on the test as reproductive rights, but know the phrase reproductive rights is a synonym for abortion rights. So, Roe v. Wade, can states restrict abortion? The Supreme Court developed a trimester plan saying that during the first 3 months of pregnancy, states pretty much can't do anything about abortion. During the second 3 months, states could restrict abortion for health of the mother, basic medical regulation. And during the third trimester, the last 3 months of pregnancy, states could pretty much do anything they wanted within a few limitations. But they came up with this system. This means that states' power to regulate abortion was limited. So you should know that Roe v. Wade limited the power of states to regulate abortion. So before Roe v. Wade, states could do anything they wanted with abortion. They could make abortion completely legal or completely illegal. They had complete freedom to do whatever they wanted. After Roe v. Wade, states were very limited in what they could do about abortion. A state could still continue to make it completely legal, but in terms of making abortion illegal, there were all sorts of restrictions. As a side note, in 2022, there was the Dobbs decision that overturned Roe v. Wade, but Dobbs is not on the FCLE. So you need to know about Roe v. Wade, but you do not need to know about Dobbs. A year later, 1974, we have the United States v. Nixon. This is President Nixon. President Nixon was being investigated as part of the Watergate scandal. If you know much about Watergate, some of Nixon's aides had broken into the Democratic Party's offices, got caught, and during this whole investigation, it was leading up to potentially Nixon it came out that Nixon recorded meetings in his office. He had a tape recorder. And so the prosecutor said, we would like to get a copy of those tapes. Nixon said, I'm the President of the United States. I'm meeting with my staff. You don't get to have those meetings. The president can have private meetings. So it goes to the Supreme Court. Nixon is claiming executive privilege, that the courts and the Senate who are investigating cannot have power over the president. That's part of our whole checks and balances system. And that if the courts or the Senate can demand these tapes, that is giving them power over the presidency. He's saying, as the executive, he is privileged to keep executive department things private. SCOTUS, the Supreme Court, I don't know if I mentioned this earlier, SCOTUS is the Supreme Court of the United States. So SCOTUS ruled that the principle of the rule of law requires that all people be treated equally under the law, and that includes the president. And in this case, the Senate and the courts were not trying to have power over the president. They were simply investigating a crime, the break-in of the Watergate offices. And in that case, the president is being treated just as any other citizen. The president is also subject to the law. The president cannot simply do whatever he wants and then claim, hey, you can't investigate me because I'm the president. Okay? So Nixon lost this case. This is not part of the SCOTUS, but it is part of one of the other competencies to know about. The issue of the rule of law, the concept of the rule of law, is that everybody has to follow law, even the president or even the king. And this goes back to the Magna Carta, and it's also in things like the Constitution's equal protection, that all citizens have equal protection under the law. There's no one special under the law or anything like that. The Magna Carta said that even the king had to follow the law. So, for example, in the Magna Carta, it said that the nobles couldn't be thrown in prison without cause. They had to have trials and stuff like that. So, rule of law goes back to the Magna Carta. Another case, later in the 1970s, the regents of the University of California. So regents are like the administrators, the board of regents. Regents of the University of California versus Bakke. Bakke was a white guy who applied to the University of California Medical School, and he was denied. Well, at the time, the University of California Medical School had a certain number of slots, I think it was 14 out of 100, that were reserved only for black people. So in order to help more black people become doctors, they reserved 14% of the slots for black people. Well, on average, the people who got accepted into those 14 slots for black people had lower scores than Bakke did. So Bakke claimed that had he been black, he would have gotten accepted. Or had those 14 slots not been reserved for blacks, he would have been accepted. So effectively, he said he was denied admission because he was white. So he claimed that this violated the 14th Amendment, equal protection, that all people must be treated equally under the law. This goes to the Supreme Court. The Supreme Court ruled that quotas do violate the Constitution. The fact that they had set aside a specific number of slots for black people was a violation of the Supreme Court, or of the Constitution. But the Supreme Court said that race could be one of several factors used in admissions. So you couldn't reserve slots only for black people, but you could consider whether someone was black and give them some sort of bonus or something like that. So after Bakke, quotas were gone, but schools used various other systems of points. There was also a case that you don't need to know about, but just as an example, there was a case at the University of Wisconsin or Michigan. I don't know, it was Wisconsin or Michigan. I don't remember offhand now. But they had a point system. You got points for all sorts of things. If you reached a certain number of points, you got accepted. And you got points for perfect SAT score or whatever your SAT score was. You also got points for being black. And in that case, you got more points for being black than having a perfect SAT score. And that went to the Supreme Court. And the Supreme Court said, yes, you can use race as one of many factors, but it can't be so heavily weighted as a factor that, you know, it's crazy. So whichever it was, Wisconsin or Michigan, they lost that. So over time, there's been a few cases tweaking this issue. All the way up until 2023, there was a Harvard case in which the Supreme Court ruled that they cannot use race as a factor at all in admissions. This is not on the FCLE, so you don't need to know that. Harvard and some other schools, though, released a statement after this and said, we can't consider whether you're black or not, but in your, well, the Supreme Court said that they could consider adversity if somebody had overcome adversity. And the Harvard released a statement saying, basically, if you're black, just write your essay on how you overcame racism and we'll know what that means. So, you know, schools have been going around with this for a long time. But officially, Bakke is the one you need to know about, and Bakke said quotas violate the 14th Amendment, but race could be a factor. 1988, Hazelwood v. Kohlmeyer. In this case, some students were publishing articles for a school newspaper. They wanted to publish an article about a girl who had gotten pregnant while she was in high school. The school principal nixed it, deleted that article from the paper. The students sued and claimed that their First Amendment rights were being violated. So can a school censor a school newspaper is the question. Supreme Court ruled that because the school newspaper was published by the school under a teacher's supervision by students who were all enrolled in a journalism class, normal people could reasonably understand that the paper represents the school. And if the paper represents the school can control what the paper is saying. So in this case, they said the school can censor it. We talked about Tinker v. Des Moines. Students do have free speech rights, but if the speech can be assumed to represent the school can control what it says. This came up another case. I don't know if you've ever heard of the Bong Hits for Jesus case. Some students were on a school event field trip, and they were going to watch the Olympic torch run by through their town, and some students held up a sign that said Bong Hits for Jesus. And they got suspended, and they claimed it violated their First Amendment free speech and freedom of religion rights. And the Supreme Court said, no, you do not have a religion that says Bong Hits for Jesus. And again, it's a school event, so you're representing the school. Okay, so you don't need to know the Bong Hits for Jesus case, though, but maybe it'll help you remember the Hazelwood v. Kohlmeyer case. Student newspaper. Students can be censored if their speech can reasonably be assumed to represent the school. Another First Amendment case, Texas v. Johnson. Johnson went to a political event and burned the American flag as a protest. He was arrested. He was charged with a crime of burning the American flag, which was illegal in Texas. He then claimed that this violated his First Amendment freedom of speech rights. So it went to the Supreme Court. The Supreme Court ruled that burning the American flag is very clearly a political act. Like, the reason you're burning the American flag is to make a political statement. First Amendment rights of freedom of speech for political speech or religious speech generally get the most protection. Those are the two things that the First Amendment was primarily created for, was to protect political speech and religious speech. So they get the highest level of protection. And therefore, burning the flag was considered protected speech. Now, they did know that there could be rules like, if you burn an American flag indoors, you could still be accused of arson and things like that. They did note, though, that when Johnson was arrested, he was not charged with a whole bunch of other crimes he could have been charged with. It was like burning without a permit, burning in a public facility. They didn't charge him with any of those things. They only charged him with burning the American flag. And they said, therefore, his punishment was for his political speech. He wasn't being punished for creating a danger. He was being punished for his political speech. And the political speech of burning the American flag was protected. But again, if you try to burn the American flag that's on the wall in this classroom, the school can charge you with arson. They just can't charge you with burning the American flag, just arson. Okay, Shaw v. Reno, North Carolina. Every 10 years, they redraw their maps, just like in the Baker v. Carr decision. Now, according to the the Voting Rights Act. The Voting Rights Act of 1965, Southern states, whenever they redrew their maps, they had to get the approval of the U.S. Attorney General to make sure they weren't discriminating against black people. Okay? So, North Carolina drew their maps, and 1 out of their 12 districts for congressional seats was going to be primarily black. The U.S. Attorney General, Janet Reno, sent it back. She rejected it and said, you need to make 2 districts that are black because 20% of your state is black. So you need roughly 20% of your districts to be black, so that way 20% of your members of Congress will be black. North Carolina did this. One of the white residents sued and claimed that this was a discriminatory act, violating the Equal Protection Clause, because it's not treating all people equally, it's treating people based on their race. So it goes to the Supreme Court. Now, as a side note, here are the 2 districts they created. So this is the second one they created. I don't know if you guys remember the term gerrymandering from school. In this case, like, you can clearly see this district was drawn in a very odd way. It was connecting majority black neighborhoods along an interstate highway system. So very clearly drawn for that. And again, remember, Janet Reno told them they had to create another black district. So it goes to the Supreme Court. Does redistricting violate the 14th Amendment Equal Protection Clause in this case? The Supreme Court decided that while it's a good intention to give proportional representation to black people, you can't make being black the sole condition of the drawing of the district, because again, then you're making race the issue. So in this case, the maps had to be redrawn. So you can draw maps in all sorts of ways, but you can't make districts primarily for racial issues. U.S. v. Lopez, 1995. A high school student named Lopez was arrested for having a gun at school. There was a 1990 law called the Gun-Free Zones Act, in which Congress banned having a handgun within 1,000 feet of a school. Congress claimed that the Commerce Clause gives them the power to do this. The Commerce Clause gives Congress the power to regulate trade that crosses state lines. I think, well, this is someone having a gun within 1,000 feet of a school. What does it have to do with trade crossing state lines? Well, ever since the New Deal, Congress had expanded their idea of the Commerce Clause, first to be anything that was made from parts that cross state lines, which guns have parts that cross state lines, but then they even expanded to say basically anything that had any sort of economic impact that affected the nation. And in this case, Congress claimed that gun violence had an economic impact that affected the entire country, therefore they can regulate guns as part of the Commerce Clause. So the question is, does this Gun-Free School Zone Act violate the Congress's Commerce Clause powers to regulate interstate trade? SCOTUS said, no, Congress does not have the power under the Commerce Clause. This was actually the first time since the New Deal that the Supreme Court had ever limited the Commerce Clause. It had just been slowly expanded to cover pretty much everything. But in this case, they said that this was a little bit too much. So Lopez, his charges were dropped. Interestingly, he was also originally charged with violating local laws against having a gun at school. But when the federal government charged him, the local government dropped all the charges because it's cheaper to let the federal government take care of it. And the federal government had stiffer penalties anyway and stuff like that. And then Lopez ended up getting those charges thrown out. So even though Lopez had a gun at high school, he ended up not going to jail. So, okay, Bush v. Gore. This is the other case involving one person, one vote. 2000 presidential election came down to who wins the Electoral College votes from Florida. When voting was done and counted in Florida, out of the millions of people who voted in Florida, Bush won by 1,784 votes. The vote was so close, the rules required an automatic recount just to double check. After the recount, Bush had just 327 votes ahead. Al Gore then asked for a recount of 4 counties, and he chose the 4 counties that had the most Democrats, or the highest percentage of Democrats. And the idea is, you might know, that every time there's an election, there's a certain number of votes that don't get counted because they didn't fill it out right, or there's some problem, like Scantrons, they didn't bubble it in dark enough, all sorts of stuff. So if you assume that Democrats and Republicans are equally likely to mess up the ballot, then if you go back and count all of these, then if 70% of the voters are Democrat in that district, then probably 70% of the new votes counted will be Democrat. So Al Gore purposely picked 4 counties that were heavily Democrat, hoping that statistically he's going to get the 327 votes. Goes to the Supreme Court, and the question was, does recounting the ballots in just those 4 counties violate the one person, one vote principle? Now, I will say, if you watch videos on this or anything, go read it. The case gets really far more complex, but you don't need to know all the details. All you need to know is the question is, does recounting just those 4 counties violate one person, one vote? And the Supreme Court said yes, because effectively what Gore was trying to do is give all the residents or all the voters of those 4 counties a second chance to have their votes counted. But all the other counties in Florida, you didn't get a second chance. So that's giving an unfair advantage to people who happen to live in these 4 counties. So the Supreme Court ruled that they had to stop the recount, and therefore George W. Bush won the presidency. Another case, 2008, District of Columbia v. Heller. Heller was a police officer who wanted to have a gun at home for his own protection. District of Columbia required everybody who wanted a gun to get a permit that the government, the District of Columbia, could issue if they felt like it. He asked for the permission to have a gun at home. The District of Columbia said no. So he sued, claiming that his Second Amendment rights to own a gun were being violated. District of Columbia claimed that the Second Amendment didn't actually give individuals rights at all. This had been a big question for years. Does the Second Amendment apply to individuals, or does it just apply to state militias? SCOTUS said, yes, the Second Amendment does apply to individuals, and therefore Heller could own a gun for self-defense. The District of Columbia's ban on gun ownership was invalidated. This leads to the McDonald v. Chicago case 2 years later. Does the Second Amendment prohibit states from banning guns? Because the issue in District of Columbia is a federal government case because it's the District of Columbia federal jurisdiction. But remember, we talked about the incorporation doctrine. Not everything from the Bill of Rights automatically applies to states. 14th Amendment says some things do. So in the McDonald v. Chicago case, the question is, can the city of Chicago ban guns? City of Chicago was claiming that, sure, the Second Amendment gives people the right to own a gun in the District of Columbia, but not here, because as a city we can do whatever we want. We don't have to follow the Bill of Rights. So the question was, is that true? In this case, SCOTUS incorporated the Second Amendment to the states and ruled that states also must follow the Second Amendment, meaning states cannot just blanket ban guns. So McDonald was able to buy and own a handgun in the city of Chicago. And our last case, Citizens United v. FEC. And if you watch the news during political seasons like this, you might hear Citizens United mentioned from time to time. It's a hugely important case when it comes to campaign finance. So there was a McCain-Feingold Act. 2 people, McCain and Feingold, got together, formed this law restricting the ability of corporations to spend money on political issues within 60 days of an election. And the idea was to limit the power of big business to influence elections. So they couldn't spend money on these political campaigns within 60 days of an election. Corporations, Citizens United, got together and sued, claiming that the corporation's First Amendment rights were being violated. Which goes to the question, do corporations have free speech? And the Supreme Court said, yes, corporations have speech. I don't know if you guys remember from economics or anything, but legally speaking, a corporation is considered a person because it pays taxes, corporations can be fined, corporations can break laws, all these sorts of things. So from a legal perspective, corporations are people. And corporations, therefore, just like they have legal responsibilities, they have legal rights, and they can advocate for their corporate interests. So corporations have free speech rights. The Supreme Court said that the McCain-Feingold campaign finance reform did violate their rights. So this comes up now every time we get towards election season and people complain about corporations spending too much money on political issues because of Citizens United. Okay, so that is the 26 Supreme Court cases you need to know. So let's review and see if you've learned some things. The state has produced an official sample test. So these are their official sample questions. Use the passage below from a landmark Supreme Court case opinion to answer the question that follows. So, if a law be in opposition to the Constitution, if both the law and the Constitution apply to a particular case, so that the court must either decide that case conformably to the law, disregarding the Constitution, or conformably to the Constitution, disregarding the law, the court must determine which of these conflicting rules governs the case. Which Supreme Court case established the precedent described in the opinion? Bush v. Gore, Miranda v. Arizona, Marbury v. Madison, Dred Scott v. Sanford. C. Marbury v. Madison, that is correct. What is the legal principle being described here?
I don't know, but I know the other three were wrong.
Okay, use process of elimination. This is judicial review. So what they're talking about here is if the Constitution and a law seem to conflict, then the Supreme Court or any federal court gets to decide. And once they decide that there is in fact a conflict, the Constitution wins, the case becomes invalid. But judicial review is the ability of the courts to decide what the Constitution means and if a law is in violation of the Constitution. So this is Marbury v. Madison, and using process of elimination is a good strategy. Okay, which of the following cases resulted in a decision that undermined civil rights and liberties in prioritization of national security? Regents of the University of California v. Bakke, Brown v. Board of Education, District of Columbia v. Heller, or Korematsu v. United States? D. Korematsu. So again, you could remember Korematsu, the Japanese internment. So we have civil rights being undermined, Japanese people put in prison with no accusation of crime, no hearing, nothing. Definitely undermining civil rights, and the whole excuse was national security during a time of war. But again, if you didn't remember that, you could use process of elimination and figure out that the two cases dealing with education were probably not national security cases. And then maybe District of Columbia v. Heller, hopefully you remember that, is a Second Amendment case. And one more. A person is charged with felony breaking and entering. During the court proceedings, the defendant requested an attorney and was denied the right to counsel. Which Supreme Court case overturned the trial court's decision due to lack of counsel? Miranda v. Arizona, Plessy v. Ferguson, McCulloch v. Maryland, or Gideon v. Wainwright? D. Gideon v. Wainwright. Yeah, Miranda v. Arizona was a similar case, but it dealt with the right to know your rights to an attorney and to not self-incriminate. But the actual right to have an attorney was Gideon v. Wainwright. And Plessy v. Ferguson, what do you remember about Plessy v. Ferguson?
Train, they wanted to sit and they ruled it separate but equal so they couldn't discriminate.
Yes, that was the separate train cars. He sued claiming violation of the 14th Amendment, equal protection by segregation, and the Supreme Court said as long as the trains were basically equal, separate but equal, allowed segregation. That was overruled or overturned by what case? What case got rid of Plessy v. Ferguson?
Brown v. Board of Education.
Brown v. Board of Education, ruled separate is inherently unequal. McCulloch v. Maryland, what is that case about?
Something with maps.
No. What was Maryland trying to do that McCulloch didn't like?
Oh, tax the bank.
Tax the national bank, right. So there were two questions. One was, can Congress create a national bank? And the Supreme Court said they can because of what clause? Necessary and proper clause.